to protect assets. And what that is that's an asset protection will. I was listening to somebody on TikTok, and what he said is, never have a will, never go through probate, never do this. And it really struck me. How can a lawyer ever say always or never when it comes to the particular type of planning tool that's right for that client? Let me give you a little bit of background. So in Washington, as I mentioned, probates are really simple here. Do they cost money? Of course they cost money. Anytime you're working with a lawyer, it costs money. Unless you're getting free services from a pro bono program. But if you're dealing with an attorney in a law office, that does cost money, period. Is it worth the benefit? That's the question you need to ask. So in Washington, if we want to protect assets for a surviving spouse against long-term care costs, the only way we can do that is if we use a will with an asset protection trust. That means that will must be probated when the first spouse dies. And then all of the assets of the deceased spouse will fund this asset protection trust. All the money in that trust will not be counted by Medicaid in the state of Washington if the surviving spouse needs long-term care. So let me give you an example. Let's say a couple has $1 million. They have a house worth $500,000. They have $500,000 in other investable assets. One of the spouses has Alzheimer's, and they're what we call the ill spouse. They won't be able to live at home if the well spouse isn't there. And the well spouse has a heart attack and the well spouse dies. As part of doing their estate planning, we knew that we wanted to protect assets for the spouse with Alzheimer's. So we did a separate property agreement. We put 100% of the assets into the name of the otherwise healthy spouse, who then later on had a heart attack. So $1 million is what is the deceased spouse's share. $1 million is going to funnel through that person's will into the asset protection supplemental needs trust for the surviving spouse. Surviving spouse is going to have to move to a care facility. They can't live at home anymore. There is the house or the proceeds from the sale of the house in that trust. There's another $500,000. There's $1 million in this trust. And you know what? Medicaid says they look at it and they say, oh, we don't count any of those assets as belonging to the surviving spouse, the one who needs care. That's Washington's rule. That's why it's so critically important. If you are concerned about protecting assets for your spouse when you're gone against long-term care costs, a will is absolutely necessary. A will means there will be a probate. Yes, there's going to be costs associated with the probate. Let's say that probate costs $5,000, $10,000. Is it worth it to protect $1 million against required spend down? That's why in the state of Washington, a will with an asset protection trust is our best planning tool. If you are concerned about making sure you don't leave your spouse impoverished because of long-term care costs, then it's a will with an asset protection trust that I would recommend.